How's everybody doing today? I hope that you had a great 2018. We're going to talk about, like I said, 12 different cases. I think that you're going to find many of them interesting. Afterwards, there's about 4 or 5 different new codes or modifications to the family code. Again, I think they'll not only be interesting, but really important to those people who practice family law. People like to ask me, well, Don, you got the corniest presentations. I mean, take a look at the slide here. You know, you got 2 people with a dog, and a lot of you are probably, well, what does that have to do with family law? Well, family law, unfortunately, has gone to the dogs. Okay, it's a dog profession now because of a new code that was passed. We're going to be talking about that later. But you're going to learn that now in family court, just like in children, the family court judge has to decide what's in the best interest of the dog or the pet. And I'm just hoping that I could get in on this, right? You have minors counsel for children. Well, I want to be a dog counsel, man. I want to be there like a dog whisperer and try to determine what's in the best interest of the dog. And my associate Danny, sitting at the table over here, and I were talking. He used to be minors counsel. I said, Danny, what are they going to do? How are they going to determine like which person gets the dog? He said, well, maybe they'll have a special room over at the courthouse, just like they have in conciliation court, and they'll have one owner sitting on one side of the room, the other one, and put the dog in the middle and see which one it goes to. And so who knows? But we're headed for some fun litigation times. If you've handled family law cases, you know that there are people that love children, and there's people that love their dogs, right? And I had this one case where a guy was filling out a schedule of assets and debts, and he listed, to the T what every dollar was on that. When it came to the dog, he put priceless. And he was going to fight for that dog to the bitter end, and he did. So I think we're headed for some interesting times. Okay, having said that, let's turn to the very first case. We're going to start with the child custody case, and it's going to be SYV Superior Court, and that can be found starting on page 3. And in this case, the appellate court provides guidance on how the 3044 presumption can be rebutted. For those of you who are not family law attorneys, what you should know is that if somebody is convicted or has findings against them for domestic violence, then the court has to find that that person cannot have joint legal or physical custody. So it's a significant thing. But the code does also provide for an avenue for somebody to rebut the presumption, and that's what this case is going to be about. So in this case, on slide 4, on August of 2016, during their marriage, the father pushed, slapped, and choked the mother, then grabbed her and locked her and her son out of their house. How wonderful, right? He's arrested, but the DA declines charges. They file restraining orders against each other. The family court denies the restraining orders, and the Department of Children and Family Services doesn't get involved in the case. Nevertheless, the relationship is over with, and in October of 2016, the father files for divorce, and he requests joint legal and physical custody. They go into family court services. They can't really work out an agreement, so there's a hearing, and at the hearing, mom testifies, and the court awards physical custody to mother with supervised visits for the father twice a week, and he's told that he cannot commit corporal punishment. Trial court also finds that these parties don't get along. There's an inability to communicate with each other, so this is a high conflict case. In October of 2017, now we're talking about down the road a little bit, there's a custody trial, and this is when the domestic violence evidence comes forward. The court actually gets to weigh the evidence. Mom testifies about the father's domestic violence. The problems arose, during his actions. He counters. He says he's got a different version of the incident, but the trial court says, she's credible. It finds that the mom was right, that he had committed domestic violence. Now, during the same proceeding, though, their father tries to rebut the presumption, right? And what he does is he says, mother is a gatekeeper. She's not letting me see the children, and she's not letting me even speak to the children. And mom, during her testimony, says, but I thought that was what I was supposed to do, which is not, by the way. Also, father testifies that he's got a very strong relationship with his children. Loves them. He's always with them. There's a great bond, and he goes into detailed explanations about going to breakfast with them, taking them to the park, the library. He reads to them books, things of that nature. He demonstrates that he's got a good relationship with his child, and this is something that's significant to this case. He also testifies that he attended a co-parenting class, which is one of the things that 3044 suggests that people do, but he hasn't completed it. He's about halfway through. The trial court finds that based on this evidence that he has rebutted the presumption against having joint legal and physical custody. And what the trial court does is it gives mom 4 days out of the week and dad 3 days of the week. And what we know from prior decisions concerning 3044 is really it was a de facto joint legal and physical custody, even though the trial court called it something different. On appeal, the Court of Appeal said, yeah, that was a joint legal and physical custody. So now the Court of Appeal has to determine whether or not this was appropriate, for the court to do such a thing. And so it's looking at the 3044 presumption. And interestingly enough, the appellate court actually affirms the trial court's decision to give this man joint legal and physical custody based on this evidence. And, for those of us who study this stuff, and especially last year, I presented a couple of cases regarding the 3044 presumption where it seemed like it was a much tougher thing to do to rebut the presumption. The appellate court here says, looking at the statute, it doesn't say that you have to complete parenting classes or batterer treatment classes. It doesn't even say that you have to enroll in them. It's just a consideration of the court. And being that father has demonstrated that he's got a very strong relationship with his child, and there's a strong bond, and it doesn't appear to pose a danger, we're going to grant him joint legal and physical custody. Now's my turn to do some commentary on this case. Okay, I don't like this case, but maybe the code is what it is, and maybe there needs to be a change. But really, what this has done is it's given the appellate or the trial court complete discretion. All they have to do is pay lip service that they've considered the case, that the factors of 3044, and they've rebutted the presumption. I think it's contrary to what we thought 3044 meant. And if you go to family court enough, you know that some of the judges don't like domestic violence cases, and this gives them a way out. So it is what it is. If you're representing a perpetrator of domestic violence, on the other hand, what are you going to do when you go to court? You're going to say, hey, look, he's got a great relationship with his kids. Look, here's pictures of him over at the park, and here's him taking the kids to school and all of that stuff, and that's what you do. Okay, enough with that. We're going to turn to the next case, which is Marriage of Connolly, which is a jurisdiction case concerning child support. So we're in the child support area right now, and we're looking at slide 13, starting with there, and then we're going to turn to slide 14. The date of marriage is 1988. There's two sons. The parties divorced in August of 2004. Shortly after the divorce, all of the parties, even though they're divorced, the mother, the father, and the children moved to the great state of Utah. And before I get any further with this, you're going to see with this case, will this guy just make up his mind? Because you're going to see that he likes to move around a lot. And it's kind of characteristic of today's society with a lot of our clients. They're always moving around, and they're giving us headaches about jurisdiction, and this is a classic example. So, they're divorced in California, but now they're all living in Utah. And what happens is father's out there for a little bit, and then he returns back to California. Slide 15. And while he's back in California, the trial court orders the father to pay child support in the amount of about $1,600 a month, and he also accumulates some arrearages by this time, okay, because he hadn't paid some of the child support that he was initially ordered to pay. The mother and father enter into a stipulation reducing his child support, and the case continues. In May of 2010, father moves back to the great state of Utah, right? Hoorah! And mom says, hey, this is my opportunity. So she transfers enforcement of the child support case from California to the great state of Utah. And while she's there, father sends sends the department over there sends a letter to the father advising him that he owes support in the amount of $65,000. So he hasn't paid for a long time. And he makes a tactical decision. He decides that he wants to have a hearing right there in Utah. So he gets this hearing, and going to slide 17, the Utah court has a hearing, and it orders that he does in fact have arrears owed to mom, but it does not include interest, because in Utah they don't do that for out-of-state judgments unless they're told to do so. And the key fact in this case here is that the mother does not contest the order. Okay, so there's a full hearing. She doesn't say, hey, weren't you supposed to tack on interest to this? It's a judgment. So now father does his next move. He goes back to the great state of California, and while he's there, Mom files a motion in Utah seeking enforcement of the judgment and wanting to modify it for the interest, and the Utah court denies her motion, said, hey, you lost your opportunity to appeal. This judgment stands. So then she goes back where father is in California court, and she tries to get a judgment using the Department of Child Support Services against him to collect not only the arrears but the interest. And without belaboring the point of the facts of this case any further, what happens is up on appeal, the trial court in California is overruled, because in California the court said, well, Utah court should have tacked on interest, and it's unfair to Mom. Well, what the Court of Appeal stated is that under UIFSA, which is the child support reciprocal statute, it's okay for an out-of-state court to make a judgment on arrears because you're not modifying the support order. We're not tinkering with the numbers at all. We're just calculating support, and under UIFSA, that's fine. Mom had her opportunity to contest this in Utah. She elected not to, and under the full faith and credit clause, we're going to say that, yeah, your motion's denied, Mom. And why did I include this? And this may be, one of those cases where you're scratching your head and say, Don, why did you include this in the packet? Well, if you're representing somebody that has similar facts where they've got a back and forth with another state, maybe they take their chances in the other state, because that's what this man did. He made a tactical decision to have it heard over there, and he saved himself an enormous amount of money. If you do child support, you know that the interest is huge, and it could actually just gobble up, anybody's hope of having any financial health. We see cases where people have arrears, $100,000 and $60,000 of interest, based on those arrears. Okay, let's turn to the next case, which is going to be Marriage of McIlvaine. I like to call this, for those of you who love RSU cases, right? You know what a restricted stock unit is? Anybody get those from their current profession? I didn't think so. We family law attorneys or attorneys, unfortunately, don't get all these perks that people have working for corporations. So this is going to deal with that, and it's also going to deal with one of my favorite topics, which is the extraordinary high earner, right? We all know about that because last year we made fun at a couple of cases like that. So in Marriage of McIlvaine, starting on slide 25, the parties divorce, or their date of separation is 2010, and post-separation, 2 years after their date of separation, the father becomes the chief technology officer for a private startup company. And he's got a compensation package that includes base salary, annual performance bonus, and grants of RSUs. 6 months later, the trial court enters their judgment of dissolution. So even though they've been separated for a couple of years, like a lot of our divorces, it's taken a couple of years to get to a settlement. Trial court enters the judgment, and what it says is that effective 1/1/13, father is obligated to pay Mom's spousal support of a base amount plus 12% of his earnings over his annual base salary, capped at $1.2 million. He's also ordered to pay child support of $5,200 per month plus 14% of his earnings over his annual base, and there's no cap for the child support. And then the parties agreed that they're going to share the specified add-ons equally, like the extracurricular activities. In July of 2013, the father's stock options begin to vest, giving him the right to purchase shares as a designated strike price. His annual income grows. He goes from $800,000 in 2012 to $2.6 million in 2014. And guess what else grows? The amount of money that he's got to pay Mom, because he's got this thing where he's got to pay a percentage over his base salary, and it grows substantially. And he says, ouch, I got to do something about this. So he files an RFO. He goes to court and he says, hey, this is ridiculous. Look how much I'm paying her now, right? That wasn't part of this. He wants a cap on his obligation. He says, Judge, look, I know I got to keep paying her child support and spousal support, but I want a cap to pay 14% of my earnings over my base salary, and let's just cap this at $1.2 million, okay? I shouldn't be paying any more than that, Now, how's he going to do this? How is he going to convince the trial court to put a cap on the amount of money that he's got to pay for spousal and child support? Well, he makes three different arguments. Actually, he makes four. The first argument, he says, I'm an extraordinary high earner. in the geographical area that I work, I fall within the smallest split percentage of the people here. With this type of money here, there's nobody that really compares to me, on a grand scale. I'm an extraordinary high earner. Just so you know, during this case, Mom contests that, but Mom loses. The court did find that, per the evidence, that the father was an extraordinary high income earner. He says this regarding the extraordinary high income status. He says, the children, their needs are met. In fact, they're kind of spoiled. This is what he says. He says that the children live well, almost extravagantly. While in Patricia's care, they're consuming gourmet foods and wearing fancy clothes, right? And they don't need anything further. Historically, this is all they've needed, and I shouldn't have to pay any more than that. And he says that by paying the current amount or the proposed amount, it won't reduce their standard of living at all, okay? Even though you're going to put a cap, or I want you to put a cap, it won't reduce their standard. The second argument that he makes is regarding the RSUs. And he's basically saying, look, Mom wants me to have income based on when my RSUs vest, right? When I'm able to sell them. And it shouldn't be based upon that. It should be actually when I sell them. And he gives the following reasons for that. He says, number one, even though they may vest, I have to get pre-approval for the sale of these RSUs from my employer. And it's not easy. I got to go through a lot of bureaucracy to do that. Now, the testimony during the trial actually showed that even though he had to go through all this red tape, the decision ultimately was his and he could sell them. The second thing he says is, I'm a good guy, right? Look at me. I am putting $450,000 shares designated for sale now. She doesn't have any evidence to show that I would do anything to harm her. And if I make my decision on this, we're going to make a lot more money, all right? We're not going to do it at the strike price. I'm going to hold on to this because this company's going someplace, and I'm going to make us all a bunch of money. So it's not even prudent to sell these things at the sale price. It should be at the sale price, not at the vesting price. Now, Mother, on the other hand, has an expert who says, well, I think that child support should be based upon his income, including income that he would derive when it's vested. And you look at the facts of this case, that judge, you're capable of doing that. Well, the trial court in this case sides with Dad. The trial court says that, Dad was trustworthy and that there was sufficient change in circumstances to warrant consideration of his RFO that he's now a high income earner, and that the vesting rule doesn't make sense in this case. Dad's trustworthy. I believe that it should be at the sale. So Dad's going to do that in the future, and everybody's going to prevail. So that goes up on appeal, and the trial court's reversed and remanded. And this is what you ought to know about this case, is that the appellate court states that when you look at 4058 of the Family Code, it talks about cash available for support. It doesn't talk about giving people the opportunity of determining when they're going to be paying support, right? If cash is available, that's what you impute, even if it's less money than would normally be if you had invested it and gotten a better deal. And it pointed out that Father didn't have to sell his RSUs in order to make his child support payments. He had plenty of assets. He could have paid it some other way. So you want to invest your money, and you're probably going to succeed, that's great. As to the extraordinary high income earner status, the court said, well, based on the evidence, it does look like he's an extraordinary high income earner. So Mom, you lose on that issue. But putting a cap, an arbitrary cap on what the children are have, well, no. What you have to do is you've got to demonstrate to us, the trial court, you have to demonstrate that you've actually articulated what's the needs of the children for somebody that's children of an extraordinary high income earner. Okay, not somebody that's historically just needed an amount of money, whether they're spoiled or not. You got to look at what children of high income earners live like, and you haven't done that. You haven't articulated that. Now, the court hints that it's most likely that Dad's going to prevail on remand, but it really instructed the court that you have to articulate, that it's the historical needs are not what you're looking at. It's what the needs of somebody that's a high income earner. So my takeaway with this case, if you're representing a high income earner, what you want to do is simply remind the court to articulate it right. They have statement of decisions. You want to coach the judge to articulate it correctly so you don't find yourself in a situation like this. RSUs are really, really popular these days. I think this was a significant case to know how these things are valued. Okay, let's talk about a new topic, and that's going to be domestic abuse, which is on page 35. And the case that we're going to start off with is Rybolt versus Riley. And I like to call these cases the wild, wild west of the domestic violence law. Okay, and you'll see why. Okay, so first of all, let's talk about time to renew. In this case, starting on slide 37, in May of 2011, mom files for a domestic violence restraining order against father. The trial court finds that she sexually assaulted mom, threatened her with bodily injury, and stalked her. The trial court then issues a restraining order, and one of the provisions is that she must stay at least 25 yards away from mom. And there's no exceptions to that. The court doesn't say, well, you get to go to the children's school and, be 10 feet from her or anything like that. Sometimes you see those limitations or those allowances in restraining orders. The court doesn't do that. You've got to stay 25 yards away from her. A year later, there's a custody hearing. And the trial court finds during this custody hearing that father really hasn't learned his lesson. He's not comprehending that he needs to back off and stop. In fact, what he's doing is he's continually trying to contact her indirectly through his family members, and he's harassing her. But because we're looking at the children, the court says what we're going to do is we're going to change the custody orders a little bit. We're going to allow dad to attend the extracurricular activities and the events at school. Okay, dad, behave yourself. All right. So that goes on, and guess what? Mom comes back into court in 2016, and she's asking for a renewal of this restraining order. And her grounds for that is hey, based upon the facts of the initial restraining order, I'm still afraid of this guy. He's still scaring me. And by the way, Judge, he's also playing games at the extracurricular activities. He's still harassing me. He's had people indirectly contact me, and I'm having a hard time sleeping because of this. Well, the trial court grants the restraining order, but during the hearing, going back, as the father, he does what I call the "I swear I didn't do it" defense, right? He denies everything. He's denying all of the stuff that ever happened. And nevertheless, the court grants the restraining order, and what the court does this time is it modifies the custody orders. It says, okay, you are. Let's see if I get this. Yeah, so it modifies the restraining order and says that, okay, you can no longer go to the extracurricular activities. Okay, you have done all the wrong things. I'm precluding you. We're going back to ground zero. No contact with the kids at the school or anything like that. Well, he brings this up on appeal. And really, when we're looking at this case, you might think that I'm bringing this to your attention because it's how do you get a renewal for a restraining order? That's not this, because this is not new law. We've covered this many, many years now, that to get a renewal for a restraining order, the person that's been victimized doesn't have to show that there's new incidents of domestic violence. All they have to show is that they're reasonably fearful based upon what's going on or what had happened. The purpose of bringing this case to you is that there was a modification of custody without the typical things that we do to modify custody. This wasn't involving an RFO for custody or a motion for that. There was no discussion of Family Code Section 3011 or 3044. This was simply, hey, mom is endangered, and we're just going to modify the order. So it's good to know for family law attorneys, when you're going into court to get renewals, that you could tinker with the parenting plan, in this type of a way. I think that there was some question about that before this decision. Now let's talk about Davida versus Mejia on slide 47. And this is the case that I definitely say, welcome to the Wild West and the rough and tumble world of DVRO hearings. Slide 48, during the marriage, husband helped raise the wife's 3 children. They weren't his children. She files for divorce. And after she files for divorce, she files for a restraining order. And here's what she alleges in her declaration. She says, husband has a history of verbally and emotionally abusing the children and threatening to physically harm me. And this is important that you see those words there, that he's been threatening to physically harm me. He threats to take the children to Mexico. and she's fearful for their safety. On November of 2016, in fact, he jumped over the gate to my house where me and my kids were at, and he wanted to take the kids to Mexico, and he threatened to abuse me. I didn't open the door to the house. I called the police, who told him to leave, and then he called me a bunch of names and made phone calls to my daughter without permission, and he also called me a bunch of abusive names on 3 or 4 times per day. So, harassing type of conduct. Husband goes and testifies at the DVRO hearing, and his defense is, I swear I didn't do it, right? This is a he said, she said. What proof do you have, right? You're saying I did all these things. You're not going to bring these kids in to testify. I swear I didn't do it, okay? In fact, Judge, you should know that she's not believable. She's committed welfare fraud, and I was there for good reasons. I wasn't there to take the kids to Mexico. So wife on rebuttal, and this is a crucial part of this decision, she's testifying, and the judge is scratching his head, and he's going, so, ma'am, do you have any other evidence of domestic violence? I mean, what else occurred? And she says, well, there was one occasion where he held a handgun to my head and threatened my life. And I had to go hide in the garage to escape from further abuse. So, husband rebuts this, and he says, wait a minute, how come she didn't mention that in the moving papers? Isn't that kind of a significant fact that, somebody held a gun to your head? You'd normally include that type of a thing, right? And they're asking you what kind of abuse, right? And by the way, she's got a history of manipulating, and I swear I didn't do it. Well, the trial court says, I find her to be very credible, okay? You don't have to necessarily have strong corroborating evidence, right? A court could just find if you're credible to issue restraining orders. It's preponderance of the evidence, and the court issues a restraining order. Now, the husband takes this case up on appeal, and basically what he's saying to the Court of Appeal is that I wasn't given the opportunity to present evidence to impeach her testimony. She sandbagged me, right? I mean, how was I supposed to know she was going to say that? And the Court of Appeal says, well, too bad, because you were put on notice that she was going to say something like this when she said that you threatened to physically harm her. Right? Yeah, so, I don't know if that really puts anybody on notice. Threatening to physically harm, putting a gun to somebody's head. I'm not really seeing that. But here's the point of this case here: is that in family court we live in the wild, wild west when it comes to putting on evidence. Right? They give you very little time to prepare. If you ask for a continuance to develop your case, to take a deposition, you're probably going to be denied. One of my associates and I recently handled a case that's very similar. I tried to get a continuance. I have really good facts, and they're supposed to. For good cause, give you continuances now. They're not. I think that in light of the consequences of domestic violence, right, you could lose custody, you could lose spousal support, or you could lose the opportunity to get spousal support, I should say, if you're a perpetrator of domestic violence. You could lose your jobs. There's a lot of consequences that go along with this, and these are summary proceedings, preponderance of the evidence, and you could be sandbagged. I would hope that the courts would start looking at decisions like this and saying that we need to really make sure the due process is obtained in these type of hearings. Okay, that's enough of my soapbox portion of today's presentation. Let's move to our next case, which is going to be Marriage of Swain, and that's going to be on slide 58, and this is dealing with the evidence. Okay, now we've got 2 cases today that are very important to family law attorneys, and that is what is your right to have a 217 hearing, or a hearing where you get to put on evidence versus just having a court decide by declaration. And there's 2 cases that deal with this special code. For you people that are not in family law, you should know that historically our courts have not allowed people to have evidentiary hearings for significant things like child custody, right? The courts were allowed to base their decisions simply by looking at the declarations, and fortunately people thought that was a violation of due process, and now there's a code that says that under certain circumstances that the court has to allow the evidentiary hearings, and that's what this is about. It's about that code, 217 of the Family Code. Okay, looking at slide 59, the date of marriage is July of 1994. It's an 11-year marriage. The date of separation, October 05. There's a stipulated judgment on February of 07. Husband's to pay the wife the sum of $2,600 of spousal support. And it says that she's going to be self-supporting by January 08. If not, the trial court can impute $2,500 per month to her earning capacity. So it's saying, yeah, you're going to get this money, but by this amount of time, you ought to be self-supporting, and that money that you receive is going to be roughly the amount of money of spousal support. In 2008 and 2009, the husband unsuccessfully filed some motions to terminate spousal support, and in fact, he probably had to pay her attorney's fees for filing those motions. In 2016, he files another RFO seeking to terminate spousal support, and in his supporting declaration, he states that he's retiring and that the wife will begin receiving her share of the retirement benefits will be in an amount close to the amount of spousal support he's now paying. Remember, he's paying her $2,600 per month, and the pension payment that she's going to get, it's going to be pretty similar to that. Wife is served, but she doesn't file a response or make an appearance at the hearing. And this is significant to this case. And what's also significant is that first trial, or that first hearing setting, the trial court continues it and orders both parties to file income and expense declarations at least 10 days before that date. So she has got an attorney, but she's not there, right? Well, wife does file an income and expense declaration, but she doesn't file a responsive declaration. And at the June 2017 hearing, she's not there again, right? You got husband, his attorney, and you got wife's attorney, but she's not there. I want you to look at this, by the way. June 13, 2017 is 12 years after the party's date of separation, 10 years after the entry of judgment. This poor guy's trying to get his support modified to an 11-year marriage. Okay, let's go back to that hearing. Husband's attorney objects to the wife's income and expense declaration because wife's not present to be there. He says, Judge, I can't cross-examine her about the truthfulness of this thing. You can't rely on the income and expense declaration. It's hearsay. And the trial court responds, okay, all right, wink, wink. The trial court then accepts a letter from the CalPERS showing that her monthly payments from the retirement would be about $2,600 per month. The husband testifies about his various ailments that prevented him from doing his job. So he says, look, this is a legitimate retirement, and the court receives that evidence. Husband's counsel then asks the trial court if the income and expense declaration is going to be received as evidence, because the hearing's about to conclude. And the attorney says, Judge, again, that income and expense declaration, I object to it. It's hearsay. You're not going to include it, are you? And the trial court replies, I wasn't going to look at it. Wink, wink, right? So the trial court then says, okay, the hearing's over. I'm going to take this under submission, recedes to its chambers, and a couple weeks later issues a statement of decision. And what does the statement of decision state? It says, looking at wife's income and expense declaration to determine her need for support, the trial court notes that it was executed under penalty of perjury and could be considered testimony, but its weight could be limited. And what does the trial court do? It reduces spousal support, but doesn't terminate like the husband had requested. It reduces the $750 per month. So the husband appeals. He says, the trial court erred by considering the I&E declaration at all. And this was a 217 hearing. I'm entitled to a full evidentiary hearing. And the Court of Appeal agrees with the father, okay, and it reverses it. And finds that wife was not available for cross-examination. The I&E, the income and expense declaration, was in fact hearsay, and therefore the trial court lacked sufficient evidence to determine that she had any need. So this is a good one for family law attorneys. This is a yay for the good guys. I think that we see people's rights trampled way too much in family court, and I'm glad to see we got an appellate court decision that talks about hearsay, right? Usually in family court, hearsay comes in and it's crazy. So what do we have to do as family law attorneys? We've got to know the evidence code, and we've got to object to hearsay when it's hearsay, right? Okay, the next case is also a 217 hearing, as I indicated. It's in remarriage of Binet, and this is starting on page 66, and I call this no sitting on the fence, please. Okay, that's this case, because you're going to find that an attorney in this case was sitting on the fence, and it hurt him. Date of marriage is February of 2002. The date of separation is January 2015. In July 21st, 2015, husband files a petition for legal separation, his preliminary declaration of disclosure, and his income and expense declaration. In July of 2015, the wife files a notice and acknowledgement of receipt of the petition and the PDD, and she doesn't file a response. In August of 2015, the husband and wife file a stipulation and waiver regarding their final declarations of disclosures and state they've been fully complied with the discovery portions of their case. They'd exchanged the income and expense declarations. They had signed the stipulation knowingly and voluntarily. So they're submitting a stipulated judgment. And what you get if you read between the lines in this case is this is one of those cases where a husband's like, let's get this over with. Let's get wife to sign this thing, because if she looks too closely, she's going to find that, she's got rights, right? So come on, you want to sign this thing? Okay, great. So he has an attorney that does all that. He files a request to enter default. He fails to include a completed income and expense declaration or a financial statement. And in November 2015, the trial court enters judgment of legal separation with property division as set forth in the marital settlement agreement. Well, now, about a year later, wife is looking at her judgment and going, didn't I get screwed on this thing? It looks to me like I didn't get some of the property that was community. What happened here? So she does what any red-blooded American would do. She files a motion to set aside, right? She's saying, he bamboozled me. And she says, he failed to support his property declarations with any type of document at all. His income and expense declaration was flawed. Judge, I made a mistake, set this aside. Now the husband, of course, he opposes it, and we're looking at slide 71, and he opposes the request, and he says that, look, her allegations of duress, are completely bogus. And by the way, Judge, here's my income and expense declaration. Here's my tax returns. You could see that I wasn't committing fraud. Look at it now. Well, wife then files a reply declaration, and she attaches his responses to some recent discovery where he refused to answer questions or produce documents relating to his finances, and says, look, this is the type of guy he is, right? Well, the trial court has its hearing, and this is the part that you got to start paying attention to. That was kind of the backup, but here's the part. The trial court swears the parties in, seeks their time estimates, and asks each side whether they will present testimony. Ma'am, are you going to present testimony? Sir, are you going to present testimony? And the attorney for the wife says, no, I'm not planning. I've submitted the documents, and I just want the court to review what we have. I could submit on the pleadings. And husband counsel states, well, providing testimony to the court might not be necessary because, the judgment was ironclad, Your Honor. So it might not be necessary. And the judge replies, I know what your papers say. You're saying it may not be necessary. You don't have to repeat that. Now, tell me, are you going to be producing any testimony? And then what happens is, the husband continues to, the attorney for the husband continues to waffle, and the documents are reviewed in court on the record. And lo and behold, at the conclusion of the court's review of these documents, where neither party asked to present live testimony, it makes a ruling adverse to the husband. Now, the husband had requested a 217 hearing prior to this. He just didn't ask for it during the hearing. In fact, when the court gave him the opportunity, he basically waffled and says, well, I may need it, but he never really went forward with it. So he has the gall on appeal to argue to the appellate court, hey, this was in violation of 217. Where's my due process? I was supposed to have a testimony. If I had testimony, I would have been able to impeach her, and we could have really gone to the truth of this. Well, the Court of Appeals says that, you had the right for a 217 hearing, but you didn't explicitly request it. You had the opportunity, you failed to make evidentiary objections, and therefore the trial court is affirmed. So what's the lesson behind this? And this is important for people that are litigating family law cases, is number one, don't assume you and the court are on the same page. You don't have control of what the court's going to do, and you think you're going to wink to the judge and say, look, if you need extra testimony, let me know. Otherwise, the documents are going to be produced. People from my firm know that when we go into a hearing, we ask for an evidentiary hearing. We put it in writing. There's a new requirement in the family law that there's a judicial counsel form you're supposed to fill out. But even assuming you've done that, when you enter the courtroom and you're about to put on that hearing, you got to get off the fence. Either you're going to put on testimony or you're not. You should remember that judges don't like to put on hearings, right? And they want to protect their records. And they don't want you to create evidence that's going to be adverse to what the ruling is. So if they could find a way out by ruling on declarations, that's easier for them, right? That's just nature, man. That's how it is. So our job as attorneys protecting our clients is to assert our clients' rights to put on testimony. You can't sit on the fence. You either do or you don't. Don't go in there and say, well, I might be able to do it. I might have to do it. So that's the lesson. Okay, let's turn to something that involves something more fun. It's called Nullity of Marriage, okay? And this is what I call the type of case that, just in case you were asked, okay? It's not going to have that much bearing on your life probably, but just in case you were asked as a family law attorney. And this involves a husband and wife who began living together in 2011. We're in slide 81. Wife was reluctant to marry husband because he's a gambler and he's financially unstable. How often do I hear that now? The women are so like solid and these bum men, you know. In addition, wife didn't want to lose her Social Security widow's benefits and never really wanted to get married again, but she loved him. Nonetheless, when husband proposed, she took out her hanky and she said yes. Okay, and she said, but it's just a commitment ceremony, right? We're not really going to get married, right? And the husband says, well, I meant marriage. Later on he testifies, I meant marriage. So they do actually have a marriage. They both go to the county recorder's office and they get a confidential marriage license. They have a marriage ceremony. There's somebody that officiates over the wedding, and that person signs the certificate, hands it to husband and wife as they're heading out on their honeymoon. And when they get back home, that certificate never finds its way back to the recorder's office. In fact, they put it into a dresser drawer and tap it and go, it's right here, right? Okay. We're not really married. So the marriage goes on for several years, right? And that certificate stays there in the drawer. It never leaves. Financially speaking, they sever everything. She's got her own checking accounts. Her property is only in her name, his the same way. But socially, they tell everybody they're man and wife. They love each other, they're husband and wife, right? This is their little secret. They're not really married. Well, the marriage doesn't go so well. And, like a lot of our cases, they end up in divorce. And what happens? Well, the husband files for divorce, and wife says, what? We're not legally married. You're not entitled to my half of the property. That's my property. Well, what happens is the Court of Appeal says, you know what? You're wrong, okay? Because when you went to and had that officiant sign that certificate, you were married at that time. Because you went to that ceremony. It was the officiant's responsibility to record that document with the county. It wasn't yours. So if you're ever asked about the validity of a marriage, now you know a little something extra. There was a couple cases recently, the last couple of years, that dealt with some different type of facts where the certificate was never signed for whatever reason. Okay, and in that case, now you don't have a valid marriage, right? And we know that in California, there's no such thing as a common law marriage. Okay, so just in case you were asked. Now we're going to turn to slide 88, and this is a case involving a premarital agreement. And this case, I like to call it the why do we need lawyers case, right? Now that we live in the high-tech society that we live in, why do we need lawyers? You've probably seen lots of professions go by the wayside because of all the technology, right? I like to think, who here, by the way, has practiced in the 1980s? Anybody here? Yeah. How about the early 90s? Mid-90s? Okay. 70s. Okay. Well, you're my expert witness then. You know, like I know, that things have changed, baby, right? I mean, the technology that we have is just incredible. The other day, my paralegal and I were looking at all the things that we have now. It's mind-boggling. Back in our day, there was triplicate forms. Back in our day, there was no such thing as a cell phone. We actually had to read books, right? We had to go and make copies of things over, That's right. And you could also smoke in the courtroom, which I loved, okay, when I was a smoker. Okay, so things have changed, right? Well, the husband in this case is really ahead of the game, right? He's like, hey, I'm one of these new guys. I don't need an attorney because you know what's going to happen someday? 200 years from now, you know what's going to happen, right? You're going to have robots going into the courtroom, right? And there's going to be a robot judge, and they're going to have due process, and our profession's gone. Well, this man's ahead of the game. He's like, I don't need an attorney. I can do it myself. I'm going to go to LegalZoom.com. I'm going to get my own premarital agreement, but I'm smart because I know that she needs an attorney, right? Somehow, he's come across on the internet that 615 of the Family Code says that, she really needs an attorney, so he hires an attorney for his fiance. And he gets his LegalZoom.com, and he proudly prepares it, and he proposes it to the attorney, and the attorney takes it and confers with his client alone. And he scratches his chin, and he takes some notes down, and he looks at it, and he confers with her. And he says, it's missing a couple of provisions in it, right? And so what he does is he makes a counter-proposed premarital agreement. He retypes it with a couple of provisions. One of them has to deal with the reimbursement rights. Another one with regard to each party had more than 7 days to review the prenup before signing it. So he's adding these provisions, which is on slide 92. Well, the problem with that, of course, is that he's giving the amended or the altered premarital agreement about 3 days before the wedding. But they're agreeing that they had more than 7 days to review the prenup before signing it. Husband signs it. Wink, wink. We're all in agreement that this didn't really happen, but fine. So they get married, and they have a great honeymoon, and I guess they had a couple of years of good years, but they ended up in a divorce. They separate in 2013, 2014, and the husband says the premarital agreement was invalid. And the wife goes, wait a minute, you're the one that started this. This is your idea, right? And he says, yeah, but you know what? You didn't present the amended premarital agreement to me more than 7 days before the marriage, and so I didn't have time. I didn't understand it. It was lack of voluntariness. They do a bifurcated trial on this issue, and the court determines that it's not enforceable because it wasn't the final version. And guess what? The trial court's upheld on appeal. So the lesson behind this is what? Never take a case where somebody wants you to do a premarital agreement where there's not a lawyer on the other side. Okay? Because guess what? This wily pro per litigant, man, he outfoxed the attorney, didn't he? We have to insist that there's an attorney on the other side. And if you ever question why that rule exists, just look at this case right here. Because if there's an attorney on the other side, that 7-day rule doesn't apply. Okay? There's decisions that say that, if there's an attorney over there, it doesn't matter if you submit that premarital agreement to the other attorney within 2 days before the marriage. Okay? It's only when there's non-representation on the other side. Okay. Now let's turn to property division. And this one's going to be a quick one. We're going to look at slide 99. I cannot pronounce this case, but I'm going to try. It's Kushesh and Kushesh Kavani or something to that effect. And this involves transmutation of a community asset. For those of you who are not in family law, what you should know is there's a whole body of law dealing with when people try to transfer or change the characterization of a separate property asset to a community asset or a community asset to a separate property asset. An example of that would be a man comes into the wedding or to the marriage with a house. He owned it 2 years before he even met the woman, right? They get married, it's in his name, and he decides that he's going to make it hers as well. So he signs a deed transferring it to her, and they get divorced later on, and guess what? It's part community and it's part separate, and there's a whole body of law with that. So that's what this is about. Okay, the characterization in this involved a condominium, and I'm not going to get into the details of this case because they're not that significant as far as the outcome of it is. Justice Bedsworth from Orange County was the one who held this. I know Justice Bedsworth. I had the good fortune of working with him when I was in the DA's office. And he's got a very colorful decision as usual. And he pokes fun at this thing where the trial court says, well, I'm not going to say that this was a transmutation when husband signs it over to wife because it didn't have the magic words in it. And what Bedsworth doesn't know that in the family law circles that we have, we talk about magic words of a document. Well, Bedsworth wasn't really impressed with that. But what he said is this is a document that is definitely on paper a transmutation. It's called an interspousal transfer grant deed. There's lots of different types of deeds. I'm sure we've got some realtors in the audience, and we also have some people that do real estate law. There's all kinds of deeds, and not all deeds are the same with regard to transmutation. Some of them aren't good enough, and there's appellate court decisions that say that they're not. My other partner, by the way, one of my partners, Casey Marti-Corena, is here, and my other partner, Patrick Bagdasarians, who's not here today, just recently won at the appellate level, arguing that a particular deed was not a transmutation. And so this is like deed by deed. So if you're representing somebody and they're saying, hey, I want to do a transmutation to somebody's separate property, use this deed because you have an appellate court decision. And surprisingly, Bedsworth says in his papers, he says, this is a case of first impression. I was really surprised to see that because I think as family law attorneys, we've always assumed that interspousal transfer deeds were good to go. And this is the first appellate court decision to say so. So it's good for your practice. Okay, now let's turn to slide 105. And this is dealing with sanctions. And the title of this for me is, how do I get my sanctions paid? How do I get paid, right? You get into court and you got this opposing party that's being mischievous, filing all kinds of motions, and the court slams that person with some sanctions, but how are you going to get paid in the case? So let's look at the facts of this case. It's a 30-year marriage. Wife is a stay-at-home mom. Husband earns a substantial salary as a bank executive. After the date of separation, she gets a job as a receptionist. He's earning $300,000. Husband and wife later agreed to a marital settlement agreement. He's going to pay her the sum of $7,500. The trial court incorporates their marital settlement agreement. They separate, their divorce is done, and they live happily ever after, right? No, of course not, because wife isn't done with the divorce in her mind. What she does is over the next 5 years, she files multiple motions, right? And they're frivolous, right? They're the same thing over and over again, maybe packaged a little different, but she keeps coming back and the husband keeps defending, and even though he's prevailing on these motions, he's having to pay her fees, and it's getting really old, right? So we get down to a hearing where she does it again. And in this hearing, the wife talks about her arthritis, her limitations, her ability to be employed. Her physician also testifies about her limitations. Husband testifies regarding his bonus and compensation package. There's really no issues. Nobody's done anything wrong. The trial court hears it and says, the husband has not intentionally concealed any funds. He's telling the truth like he always does. I'm not modifies spousal support order, putting a cap on the amount he's got to pay her. And then he declines to order sanctions against the husband because, once again, the wife was asking for it. But he orders sanctions against her, $50,000, pursuant to Family Code Section 271, for repeatedly filing and dismissing motions and pursuing frivolous litigation. I love this. You get some judges in family court that don't want to pull the trigger, but when you get one to pull the trigger, it's sweet. Okay. So, trial court permits the husband to withhold $25,000 per year from the wife's share of his annual cash bonus, because remember, he's got this spousal support. And wife appeals and says, "Wait a minute, you're mixing apples with oranges. That's my money. That's my lifeblood. How am I going to live? You're taking money from me. That's my income." And the Court of Appeals says, "Too bad. 271 provides that payment of sanctions must be made only from the property or income of the sanctioned party. The statute does not preclude this, so I'm going to allow it." So I put this in here because this is a nice, sweet way of maybe getting some of that sanctioned money and deterring people from terrorizing our clients, 5 years after they're divorced. Okay, the last case we're going to cover is a case that pertains to spousal support, and I call this, well, what were you expecting? That's my title for this case. What were you expecting? And we're talking about in remarriage of TC and DC, slide 116. It's a 19-year marriage. They separate in 2012, and in 2014, the parties finally enter into a marital settlement agreement. And the marital settlement agreement has some specific language that you need to pay attention to here. Okay, wife and husband agree that wife will pay $850 per month to husband as base spousal support from July 13 to January 2021. Which would meet the husband's reasonable needs consistent with the marital standard of living. There's another provision in this marital settlement agreement. Wife is also obligated to pay 10% of any yearly earnings over $180,000 to husband as additional spousal support. If you look at this language here, you can see that the base says that it's reasonable needs consistent with the marital standard of living. That means that, as long as she's paying that, he really shouldn't be entitled to any more for that base because they're saying that's enough. But the second provision is wide open. There's no cap on that, right? He gets 10% of anything she's earning over $180,000. And then there's another provision that the trial court can consider their earnings during the marriage, which are pegged, and there's some history of what it is, okay? There's a subsequent modification, but that order pretty much stays intact. Going to slide 120, slide 121. In 2016, wife has the ouch factor going on, right? Her income is like substantially increasing. She's making buku dollars now, something that wasn't anticipated. And, she's finding out, like the husband we talked about earlier, she's having to pay a whole bunch of support to him, and she doesn't like it. So in December of 2016, she files a motion to modify spousal support, and she's arguing that her newest job came with a higher salary and bonus potential of up to 40% of that salary, and paying according to the MSA requires would exceed the marital standard of living and give husband a windfall. She's saying, look, this wasn't even close to what we were accustomed to during the marriage. Look at the amount of money he's getting paid. Well, the trial court finds that, this is grounds for a modification. This is a dramatic increase. Okay, so you get to come back in and say that it could be modified. And I do believe that, this is exceeding the marital standard of living. Husband's expectations was that he would receive $990 in additional spousal support, not the $19,000 that he would get regarding, with respect to her new package. So, before with that bonus and him getting 10%, he's only getting $990, but now you're talking about $19,000. Trial court's ruling, we're not going to change the base support payments, but we're putting a cap. We're definitely putting a cap now on this. Father appeals, and it's reversed. And it's reversed essentially because of the fact that you have to look back at that marital settlement agreement. It was left open-ended. There was no grounds for this court to put a cap on it. The Court of Appeals said that marital settlement agreements are like contract law. And what the Court of Appeal or the trial court has to do is read the provisions and give them their just meaning, right? And when there was 10% above $180,000, that's what it meant. Now, the court did say that you still have to consider the marital standard of living, though. And this was a modification, and wife's income drastically increased. It said, looking at the marital settlement agreement, it's clear that these parties intended for there to be modifications because wife was on the upswing. And if you look at the past 5 years, she was getting these increases in her pay, so it would be appropriate for the court to give a modification up to the marital standard of living. But in this case, that's not what the trial court did. It just put a cap. It just said, we're done. And so what is this case all about? This case is about being very careful how you draft your provisions for marital settlement agreements. Spousal support, we've seen it over the past couple of years. You got to be very careful as you're describing bonus. It seems like we're getting into a lot of trouble with Osler-Smith types of language. If you mean for there to be a marital standard of living cap, you should include that. And I don't know if we have any forensic accountants here today. I don't think we do, but it's not a bad idea to get a marital standard of living analysis done and incorporating that into the agreement if you can. Okay, so those are the cases that I'm going to cover today. Now let's take a look at some of the new legislation. And we're going to take a look first at slide 127. 4320 of the Family Code are the circumstances that need to be considered by the court in ordering spousal support. And there's been a change to subsection I with respect to domestic violence, right? And what has happened is that the code has been expanded for the things that the trial court has to consider. And without going into line by line of this thing, this is a substantial increase of what the court's allowed to consider when determining whether or not somebody's entitled to spousal support or not entitled. Family Code Section 2605, which is slide 128, is our dog statute or our pet animals. It's not just dogs, obviously. It could be snakes and gerbils and all kinds of fun things. The thing that I found interesting when I read this code, and I apologize for the small print for those people that are my age or older, it does actually say that the court has the jurisdiction and may assign sole or joint ownership of a pet animal. So the court could actually say like joint custody almost, except for, of course, there's not going to be any of this coming back from modifications because we're still talking about property. But the court could order that husband and wife, you're going to jointly own this dog. And I could only imagine the litigation that this is going to create. I mean, it's going to be fun times for us. The other thing is that best interest of the pet standard. The court has to take in, and again, going to my associate attorney, I love his idea, man. Is put the dog in the middle of the room and see which one it runs to, and hopefully nobody doesn't have any biscuits in their pockets or anything like that. Okay, next one is slide 129, and this is the annual gross income of each parent. Now, this is probably the most important modification of our family code that for 2018 or 2019. And basically what it says is that the court can impute income to a parent, but it's got to be consistent with the best interest of the children, taking into consideration the overall welfare and developmental needs of the children at the time that parent spends with the children. And that's consistent with a case that's called marriage of fight. Okay, we've had these competing cases. One is Labas and Muncie versus Fight. You had these competing cases as to whether or not a trial court could impute income to a primary caretaker, especially when there's small children. And you see these attempts all the time. And I've seen some courts impute income to mothers who have to stay at home for their kids. And a lot of times it doesn't make sense. It's not good for the kids, and certainly not financially doesn't make any sense. Well, this is actually putting some teeth and some direction for what the trial courts are going to have to do now. I like this because in most cases, especially when you're dealing with high income earners, like husbands that are earning $1 million a year, and wife is at home with 3 children. And yeah, she could get out and get a $60,000 a year job. It's not going to make that much difference in support anyways. Why not, for the best interest of the children, say no, they're not going to impute income to her? And that's what this is. So I applaud this change. The next two, and the last two sections we're going to look at are on slide 130, and then then 131 and 132. 130 deals with people that are violent sexual predators, and they're convicted of felonies. They've gotten really serious with the consequences, and I'd say so serious that we're almost into the punitive stage here. Family court is not supposed to be a place where we penalize people. If we put them in jail for contempt, it's supposed to be teaching them lessons. They don't really spend time in jail anyways. But this looks like it's serious punitive stuff here, because if somebody's convicted of a felony of sexual offense against their spouse, they're going to lose their right to spousal support. They're not going to have their community property anymore, because that's going to be given to the other side. Attorney's fees are going to be, for the wife, is going to be paid out of the community. For the victim, it's going to be paid out of the community estate. Now, the shocking one is the next one is 4325, which is not dealing with sexual abuse per se. It's dealing with convictions for domestic violence. And in this case, the print is very small, so you're not going to be able to read it. But I did take a copy of this before I came here today. And this says it's very similar. If there's a conviction for misdemeanor domestic violence within the past 5 years, the trial court has the discretion of ordering 100% of the community property to the victim, and also can find that there's no spousal support if the perpetrator is asking for it, and the evidence is by preponderance of the evidence. So very draconian type of language. It gives the court wide discretion, and we'll see what this does for domestic violence in the future and how we're going to be playing in court. Okay, so other than that, again, turning to the index in the back of my materials, there are many cases that I didn't cover today. There's some of them that are significant that maybe should have been in here. I only had so much time to prepare, and I only had an hour or so to give the presentation. So I would strongly encourage you, if you're a family law attorney, looking at the index for the cases that weren't covered, because they're significant. And that's all I have for today. Thank you again for inviting me.